Now on to page 3 of the contract for the resale condominiums. Under 4.8, the seller's lawyer is going to take the purchase price to pay out the mortgages, condominium contributions, registrations, any other financial obligations, and then within a reasonable period of time the seller's lawyer provides the buyer's lawyer that all the discharges were done, including there's a certified copy of the certificate of title, and there's an estoppel certificate showing that the payment of all condominium contributions are fulfilled. Under 4.9, the seller will pay the cost to prepare the documents, register, discharge, and so on, and the buyers will pay the cost to prepare, register, and discharge on their side. 4.1, if the property is rented and the buyer is not assuming the tenancy, then the seller themselves is responsible for all costs related to ending the tenancy and giving vacant possession to the buyer. 4.11, if the property is a condominium unit that creates a lot, like a bare land condominium, then as part of the normal closing documents, the seller will provide a real property report that reflects the current state of improvements according to the land surveyor's manual, and it's going to show municipal compliance or non-conformance. And this obligation will not apply to any transaction where there's no structures on the land. And finally, in 4.12, notwithstanding the closing provisions in the contract, the parties instruct their lawyers to follow the conveyancing protocol, which may be used in case the transfer of funds hasn't been completed or there's some other delay that both lawyers are in agreement to, allowing possession to occur even though a few of these either documents or funds haven't come across to one of the lawyers. Now, in section 5, insurance. Yes, the risk of loss or damage lies with the seller until the purchase price is paid in full under the terms of the contract. So if there's damage before the purchase price is paid, then the insurance proceeds are held in trust for the buyer and the seller according to their interests in the property. Now in section 6, this is what the seller is representing and warrants to the buyer. Well, first of all, they've got the legal right to sell it, and that the attached and unattached goods, they're in normal working condition and they're free of all encumbrances. The seller is not a non-resident for the purposes of the Income Tax Act. The current use of the building and the land complies with the existing municipal land use bylaw. Under E, the building or any of those improvements are not placed on an easement or a utility or right-of-way or encroach on the lands except where there's an agreement registered on title, or in the case if it's a municipal one, that the municipality has endorsed that encroachment directly on the real property report, which you would see. F, the location of the buildings and other improvements on the land complies with all the municipal bylaws, and it also would indicate if the land has any non-conforming buildings as defined by the Municipal Act. Under G, the current use of that land and buildings and the location and the improvements complies with any restrictive covenant on the title. And H refers specifically to the current monthly contribution that's payable. And then I, unless otherwise disclosed, the seller is not aware of any defects that are not visible and could render the property dangerous. And finally, J, the seller is not aware of any outstanding special assessments except as otherwise disclosed. So they're warranting that there's no special assessments coming up on this condominium. 6.2, the representatives warrant that anything that's contained in this contract or any other attached schedules is true unless otherwise agreed to in writing. 6.3, it says the warranties and representations may be enforced after completion date, provided that the legal action is commenced within those time frames underneath the Limitations Act here in Alberta. And in 6.4, both the buyer and the seller each acknowledge that unless otherwise described, there's no other warranties, no other representations or collateral agreements made by or with the other party, and that the size and measurements and so on are not warranted in this, and there's no existence or non-existence of any environmental condition or problem unless it's noted within the contract. Okay, let's move on to 7.1. All these times are Alberta times. 7.2, the contracts for the benefit of the heirs and the people purchasing it, or administrators or executors. 7.3, any changes shall be made where required. 7.4, contracts governed by the laws of Alberta, the province of Alberta, and anything that needs to be done would be held within a court in the province of Alberta in regards to any disputes.